Good morning and welcome to our June 27th Law and Regulation Committee meeting. I will call our meeting to order and ask our clerk to call the roll.
Vice Mayor Bernasconi.
Here.
And Councilmember Mendonça.
Here. I'd like to ask our Deputy City Clerk, Helen Dwyer, to lead us in the pledge, please.
Please join me in the pledge. I pledge
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. At this time, I will open up the meeting for public comments. Seeing none, I will close public comment. And we will go to item 5, minutes from the prior meeting. Any changes?
No changes.
Okay, me either.
Then we have consensus to approve the minutes.
Great. Okay, we'll now move on to item 5.2, excuse me. And I'll kick it over to Mark Walensky.
Good morning, excuse me, Chair Mendonça and Vice Mayor Bernasconi. Once again, I'm Mark Walensky, Government Relations Administrator, and the following report includes an overview of an assortment of legislation with areas of particular focus on state ballot initiatives, public safety, building, housing, divestment, campaign contributions, and at the federal level, the appropriations process. Joining me for the presentation is Rob Becerra, Program Manager, and at this point, I'd like to turn it over to Rob for his portion of the presentation.
Thank you, Mark. I'm going to cover specifically an overview of active legislation related to law enforcement, fire, building, as well as 2 initiatives. Recently, and I know this information was sent to you, the Supreme Court recently made a decision on the Taxpayer Protection and Government Accountability Act. The Taxpayer Protection Act aimed to make passing new taxes and fees more difficult by requiring voter approval for statewide taxes and raising the voter approval threshold for some local taxes to 2/3. It was backed by the California Business Roundtable and the Howard Jarvis Taxpayers Association and funded largely by real estate interests. Governor Gavin Newsom and top legislative leaders challenged the measure, arguing it was unconstitutional as it altered the basic structure of government. The Supreme Court unanimously ruled that the measure was unconstitutional and not an amendment requiring a different approval process. The rationale was the measure would substantially alter the basic plan of government, thus cannot be enacted by initiative. The decision, they stated, reshapes the initiative landscape ahead of the November ballot, so impacting the dynamics of other proposals at play. Downrange, there are financial and strategic shifts that we believe that we will see as interest groups now redirect their funds onto other efforts that remain proposals on the ballot. And the ruling does set a new precedent regarding the state's role in determining which measures can appear on the ballot before voter consideration. Proponents of this initiative had anticipated the court's support based on past precedent, believing that ballot issues are typically decided by voters. The second initiative I'll discuss is an update to the Homelessness, Drug Addiction, and Theft Reduction Act. As we have previously reported, the Californians for Safer Communities Coalition submitted over 900,000 voter signatures. Earlier this month, the Attorney General's office did certify the initiative for the November ballot, confirming they had achieved the threshold of just under 550,000 votes they needed. As a reminder, the key proposals of the initiative were focused around drug and mental health treatment, tougher laws on drug dealers, and revising theft penalties. The government relations team is planning to bring this to the full council in August for further consideration, recognizing the significant support we heard from this committee, filling the value to move it forward to the full council. Moving on to police legislation. You will see through the next series pieces of legislation. Some you have heard before, some you have not. We have moved to the position stage now, feeling many of these pieces of legislation are far enough along that based on the legislative platform, we felt it was appropriate to provide support opposed positions. So 2 police-related bills, AB 1990 for criminal procedures around shoplifting. This authorizes warrantless arrests for misdemeanor shoplifting not committed in an officer's presence if there is probable cause, provides practical method for addressing misdemeanor shoplifting enforcement challenges. We recommend, based on the legislative platform, supporting this bill to deter future retail theft. AB 1779, also related to theft, expands the jurisdictional rules for theft crimes to include actions by county district attorneys. It allows for the aggregation of offenses related to retail theft across multiple counties, and it enhances the coordination among district attorneys to combat organized retail theft rings. Again, recommending a support position on this to ensure accountability and reduce organized retail theft. Moving on to one piece of legislation from Fire, AB 1168 around emergency medical services. This ensures cities or fire districts retain pre-hospital EMS authorization in part of their joint powers agreement. Although not directly affecting Roseville, supporting this allows other public agencies to retain their transportation rights, their transportation or their transport rights for EMS services. This is being supported by the League of California Cities, and we also recommend a support position just to retain local control over EMS services. And moving on to the last piece of legislation I'll cover, coming from our building department. This is AB 2433, California Private Permitting Review and Inspection Act. We're recommending and oppose unless amended. This requires building departments to post fee schedules on their website, but it also introduces an unreasonable timeline or a shot clock for approval of complex projects. The suggested amendments to this legislation by the California Building Officials Association suggests expediting certain permitting processes, but leaving others alone. This bill has not been amended yet to allow for the deconstruction of those permitting processes being separated out, and instead would make it extremely challenging for building departments to meet this new restriction on timelines. So we would recommend and oppose unless amended, based on also our partners at California Building Association in their agreement. With that, I will pass it back over to Mr. Walensky.
Thank you, Rob. Moving forward, the first bills that I'll be reporting on relate to 2 bills on housing. The first bill is AB 1657. This bill would enact the Affordable Housing Bond Act of 2024, which, if adopted, would authorize the issuance of bonds and provide that the proceeds from the sale of these bonds would be used to finance programs to fund affordable rental housing and home ownership programs. The city has a watch position on this bill to understand the potential resources that might become available to address the affordable housing crisis throughout the state. We know that according to a 2022 statewide housing plan, there are approximately 2.5 million additional housing units that need to be built in California to address the housing crisis. The next bill is Senate Bill 1037. The planning and zoning law requires a city or a county to adopt a general plan for land use development within its boundaries that includes, among other things, a housing element. This bill would create new legal remedies that can be used by the Attorney General to enforce the adoption of the housing element revisions or to enforce any state laws that requires a local government to ministerially approve any decision or application for a housing development project. The city has taken an opposed position on the bill for the fines that could be levied against a local government for being out of compliance with their housing element, and that the bill requires that the penalty is automatic without an opportunity to cure. In addition, the bill does not consider whether a city is acting in good faith. Under existing law, cities can be subject to significant fines and penalties for violating certain housing laws. However, before fines are imposed, a city can correct the action. Additionally, enhanced fines are not imposed unless the city fails to follow a court's order or acts in bad faith. Unfortunately, as currently drafted, SB 1037 does not provide an opportunity for cities to correct an honest mistake or address a genuine difference in the interpretation of the law. Even those jurisdictions acting in good faith could be subject to significant fines and required to pay the Attorney General for all costs investigating and prosecuting the action, including expert witness fees and attorney's fees. Moving on to broadband and divestment. Assembly Bill 2708. Current law requires the Office of Broadband and Digital Literacy to oversee the acquisition and management of contracts for the development and construction of, and for the maintenance and operation of, a statewide open access middle-mile broadband network. The city is supporting this bill as it would add new information and understanding of the statewide broadband network, and for the benefits this would provide towards directing broadband funding to those areas in the state with the greatest need and to areas being underserved by service providers. With regards to Senate Bill 252, this bill would prohibit the boards of the Public Employees Retirement Systems, or CalPERS, and the State Teachers Retirement System, or STRS, from making new investments or renewing existing investments of public employee retirement funds in a fossil fuel company. The bill would require the boards to liquidate investments in a fossil fuel company on or before July 1st, 2031. The city has taken an opposed position on this bill due to the potential implications the bill would have on Roseville and other municipalities and agencies that participate in CalPERS and STRS systems. Many public agencies utilize these systems to provide retirement benefits to their employees. Thus, with what would be required by this, what's required by this process is that for both boards to make fiscally prudent decisions to protect the financial security of their members. To improve the funded status of our employee pensions funds, it's critical that CalPERS and CalSTRS have healthy investment returns. Recent market turmoil demonstrated the challenges to achieving those returns in 2022. Divestment makes achieving the returns needed to maintain plans healthy more challenging. According to a CalPERS publication entitled CalPERS and Divestment, divestment limits investment opportunities, decreasing diversification, limiting returns, and increasing risk in our investment portfolio. With employer contribution rates stretching employer budgets thin, it would not be prudent to take actions that would further increase employer contribution and put continued strain on local budgets. With respect to ethics and campaign contributions, Assembly Bill 2631. Existing law requires each local agency official to receive ethics training every 2 years that includes training on their ethical duties under the Political Reform Act of 1974 and on other ethics principles and laws. This bill would require the Fair Political Practices Commission, or FPPC, to create, maintain, and make available to local agencies an ethics training course. The city has a support position on this bill because the bill would codify the FPPC's ethics training program in statute, thereby making it a permanent program that can be relied upon by local officials indefinitely. The bill would ensure that local officials continue to have free and convenient access to a resource that educates officials and staff on important ethic laws that impact their work, and decision-making. With respect to AB 2911, the Political Reform Act of 1974, among other things, prohibits certain contributions of more than $250 to an officer of an agency by any party participant or party or participant's agent in a proceeding while a proceeding involve a license, permit, or other entitlement for use is pending before the agency. This bill would limit the prohibition on the contributions made during and after a proceeding to the 9 months before and after a decision in a proceeding is made, and would extend the period during which an officer may cure a violation to within 30 days of accepting, soliciting, or directing the contribution. The city has taken a support position on this, the second Levy Act bill introduced this year. The city has also taken a support position on that bill, which is SB 1243, which we brought before the committee in a previous meeting. This bill is a realistic measure that would raise the threshold for contributions regulated by the Levine Act from $250 to $1,000. The measure would also extend the time allowed to cure certain violations by returning a contribution from 14 days to 30 days. This change will ensure that the time in which a local official can cure is uniform and allow for enough time to identify and correct a contribution without being penalized. And then moving on to the federal appropriations process and earmarks. The fiscal year 2025 appropriation season is well underway, with the House of Representatives having more than half of their dozen annual spending measures having moved through their respective subcommittees. Staff learned yesterday that the House GOP appropriators are proposing to reduce funding at the Department of Transportation, or DOT, aiming specifically at discretionary grants that appropriators feel duplicate money already provided by the 2021 infrastructure law. In addition, the House Committee on Appropriations released a proposal to cut funding for the Department of Housing and Urban Development, or HUD, programs in the fiscal year 2025 spending bill. Overall, the proposal would fund HUD at $73.2 billion, or about 3% less than the previous year's funding level. It's expected that the House Appropriations Committee Subcommittee on Transportation, Housing, and Urban Development, or THUD, will hold a review of the fiscal year 2025 spending bill for transportation and HUD programs today, with a full committee review slated for July 10th and a vote on the House floor scheduled for the week of July 29th. Staff is watching this closely to better understand the final proposed funding level for this bill that includes important transportation and housing programs and services. It's important to understand that the funding level for HUD this year, in the 2024 appropriations year, was flat. And during our federal advocacy trip, we learned from HUD and other agencies about the importance of the HUD funding and the implications of that flat line to the programs and services that are being provided by those departments, particularly by HUD. And so we had conversations with our members of Congress and with HUD staff about flatline and what this reduction could mean in the future if there was continued cuts or flat line to the HUD budget. And it was daunting, to say the least. For our housing agency, housing choice vouchers would be something that would be impacted significantly if the funding is continued to be reduced. And just as a reminder, what happens now, as the House goes through their 12 appropriations bills, on the Senate side, the same thing happens. The Senate has the same 12 appropriation committees that are meeting. And what will happen once the House and the Senate have moved through that process, they'll come together in a reconciliation process to find funding levels for each of those bills, and those will be the bills that will ultimately be voted on by Congress. And then moving on to city projects that were accepted on the general fund side as earmark request, City General Fund Department submitted 2 projects for consideration through the Community Project Fund funding and the congressionally directed spending or earmark process. The Public Works Department submitted the Highway 65 Bike Pedestrian Overcrossing Project, which is a $6.6 million project, for the design and environmental work for a project that would provide a pedestrian and bike overcrossing of Highway 65. And the Parks, Recreation, and Libraries Information Technology and Public Works Departments submitted the Adventure Club Broadband Project, which is a $2.8 million project to provide improvements and upgrades to the internet service and related technology to Roseville's adventure clubs for congressional consideration as well. And both Senator Butler and Senator Padilla have included these projects in their congressionally directed spending request. Staff continues to monitor the actions on the federal budget through the remainder of the year, including what short-term actions Congress may take to avoid a government shutdown later in the year. And this concludes our presentation, and we're prepared to answer any questions you may have.
Thank you, Mark. Thank you, Rob. Vice Mayor Bernasconi.
I don't think I have any questions. Thank you for the information.
I just have a couple. On AB 1990, the criminal procedure arrest matter. So does this take it back to the days where loss prevention doesn't have to necessarily call PD anymore if PD just observes it, or if they don't observe it and they just call and say, hey, they're in the store, conducting a criminal activity, then loss prevention wouldn't have to make the contact. PD could come in and make it because they didn't have to witness it?
You're going down the same track, which is loss prevention can be that witness where you don't have to come into play the video camera footage, an officer on viewing something. So it does take out that element of an officer having to on view the crime personally, and so it does put a little bit more control in loss prevention. Hopefully kind of expediting the process to be able to arrest someone for shoplifting.
That's great, because so many of these stores now are taking more and more of that hands-on approach. This would be key, especially for many of our retailers. And then on SB 1037, I know we're opposing that, but are you aware in the back channels, are there any dialogues going on to possibly, open up the conversation to allow the cities to cure those violations, or is that pretty much is a hard no all the way around?
It's been a hard no up to this point. There haven't been any amendments that have been taken on that, and so that's why we continue to oppose.
Sad. Okay. Thank you, gentlemen. I'll open it up for public comment. Seeing none, I will close public comment. And we'll move on to item 6.2 in today's agenda, and we'll get an update on priority legislation from our electric department. Good morning, Amber.
Good morning, Chair Mendonça, Vice Mayor Bernasconi. Today, for the legislative and regulatory overview for the electric department, I'm going to start with some of the state legislation that we've been following, and then I'm going to give an update on the cap and trade program as part of our state regulatory, and then I'll move on to some of the budget impacts from an energy perspective that we've been following as recently as this week. So the first bill that I'm going to introduce is the California Energy Commission's Energy Resource Program Account, or ERPA, trailer bill. In late May, the Senate and Assembly budget subcommittees both voted to reject the California Energy Commission's budget proposal that would have raised the statutory cap on the CEC's ERPA surcharge and extend the surcharge to the behind-the-meter electricity consumption using a complex formula that estimates solar generation. The electric department had ongoing concerns with this proposal to increase costs to our customers, as well as concerns with the implementation of the behind-the-meter component of the legislation, which would have required us to spend significant time and resources reworking our billing system. We opposed this legislation with our trade associations, and we were supportive of the committee's decision to ultimately reject this bill. However, because this is a priority for the Energy Commission, it's likely that a similar proposal could resurface in the future, even next year. So the department has a watch position on this kind of general proposal for now, but we expect that this will come forward again. The next bill, AB 2815 by Petrie Norris. This bill would require the CEC to provide funding through the Clean Transportation Program for the repair or replacement of non-operational electric vehicle charging stations that are at least 5 years old, that were installed before January 2024, and that are located on publicly available parking spaces. Staff has been monitoring this bill to determine if it could provide any potential benefits to our community in the future. And we are bringing this bill before the committee again this month to note that the bill does remain silent on whether the repair or replacement due to vandalism is eligible for funding. And we know that was a question that was brought up at one of the last L&R committee meetings. The next bill, AB 1834, regarding resource adequacy and electricity supply strategic reliability reserve program. Last year, there was a bill signed by the legislature, AB 1373, that, and it was enacted, enables the Department of Water Resources to act as a central procurement entity for diverse clean energy resource procurement. And this was voluntary in terms of publicly owned utility participation, but that bill required POUs that did participate in the central procurement entity to fund participation through a non-bypassable charge on their customers. So what AB 1834 does, it really follows up on that legislation from last year and allows POUs to use an alternative mechanism other than the non-bypassable charge if they choose to participate in the central procurement process. Essentially, this bill creates more flexibility for participation in that process, and we support flexibility in the case that we may want to use that mechanism sometime in the future, although we are not currently participating in that mechanism. The next bill, AB 2037, dealing with weights and measures of electric vehicle chargers. This bill would authorize a county sealer to test and verify as correct any electric vehicle charger operated by a public agency that is located in the county in which the sealer has jurisdiction. The bill would require a county seal to designate a charger with the words "out of order" and require the charger to be repaired or corrected if upon testing it finds that the electric vehicle charger is incorrect. And the charger must be repaired or corrected within 30 days. It would also authorize a county board of supervisors to charge an annual registration fee for the cost of inspecting and testing electric vehicle charger operated by a public agency, and would authorize the county sealer to level a penalty against a public agency or a vendor contracted by the public agency to provide and maintain electric vehicle charger services on behalf of the public agency in the case that they were to remove or obliterate a tag placed on the electric vehicle charger that was operated by the public agency. The city supports ensuring the accuracy of electric vehicle chargers, and there are ongoing negotiations underway regarding whether publicly owned utilities should be able to do some of this verification on their own, separate from the county sealers. So we're remaining neutral on this bill and watching it, but there's been a lot of ongoing discussions, and we're continuing to monitor the outcome of this bill. And then finally, for the legislative side, on SB 1420, we have a bill that we've been watching on hydrogen. This bill was recently amended earlier this week and has been pared back significantly. The bill still talks about clean hydrogen for use in transportation sector. However, specific definitions around qualified clean hydrogen projects have been struck. In addition, the language that previously talked about the streamlined permitting process is now limited to projects receiving state or federal funding. In any case, the electric department is watching the hydrogen debate with the goal of encouraging new hydrogen laws to be flexible so that utilities can use these resources to affordably meet our clean energy needs as this technology comes to scale in the future. And then moving on to the state regulatory items. The California Air Resources Board is continuing to update their cap and trade program with proposed changes expected to be approved by the end of this year. And CARB's proposal speaks to increasing the stringency of the cap and trade program, which regulates greenhouse gas emissions from covered entities. Roseville's been working closely with our trade associations to support minimal changes to the existing regulation, especially with respect to allowance allocation, consignment of allowances, and use of allowance value, which are the three primary areas of focus for CARB in relation to electric utilities. And it's important because many POUs, publicly owned utilities, made investment decisions and portfolio projections based on a program that would run through 2030 without these kind of changes occurring midway. We remain active in monitoring the potential changes to the program, and we've been participating in meetings with CARB staff, and we recently worked with our trade associations to submit comments to CARB last week. So we'll continue to keep the committee apprised of any changes that come out of this process. And then lastly, in terms of state budget and energy impacts, this has been fluid even through this week. But the legislature recently passed their major budget bill and is in the process of finalizing budget deals this week ahead of the start of the fiscal year. Budget trailer bills could be ongoing through the end of session, but we expect the main items to be pretty far along by the end of this week. Given the shortfall that the state has been trying to address, we were following impacts to the energy sector, including shifts from the general fund to the greenhouse gas reduction fund program, and then any general cuts to the energy program, many of which were listed here on this slide. Of primary importance to us was funding for the Distributed Electricity Backup Assets Program, or the DEBA program, which was proposed for reductions by the Department of Finance. This is important because, as you know, we've been notice a proposed award for $1.5 million through the DEBA program, and so we were watching this closely. While there have been cuts to the DEBA program is still left with $532 million total, and has been authorized the flexibility to use $75 million from another program that the Energy Commission is in charge of as well. So we'll continue to monitor any state budget outcomes that may impact the department and keep the committee informed regarding the implementation effects, if any, related to the cuts. And with that, I'm happy to answer any questions that the committee may have.
Thank you, Amber. Vice Mayor Bernasconi?
Great overview, Amber. I don't have any questions.
I don't either. So at this time, we'll open it up to public comments. Seeing none, I'll close public comment, and we'll move on to item 6.3, and we'll get an update from our environmental utilities. Good morning, Noel.
Good morning, Chairman Donza and Vice Mayor Bernasconi. So recently, the legislature hit the halfway mark in the year, which means bills had to make it out of their house of origin in order to continue on. This morning, I have broken down my presentation by bills that, how we refer to them, they're still alive, which means they're still moving through the process, or they are dead, which means they will no longer be moving this year. Additionally, I will provide an update on the Making Conservation a California Way of Life regulation, and we'll close out with an update on EU's congressionally directed spending request. The first measures I will cover this morning are bills dealing with the ability of local agencies to collect connection and capacity charges. As we've seen over the past few years, the legislature has introduced legislation that they believe will spur housing development. Their focus is generally on limiting local government's ability to manage growth and our ability to collect fees to mitigate the impact on current residents or eliminate the requirement of new homes to pay for their fair share of connecting to existing systems. This year was no exception. There were a number of bills introduced aimed at limiting the ability of local governments to collect connection and capacity charges. I am happy to share with the committee that we have been successful in obtaining amendments to all of the bills that removes the water and wastewater industry's opposition. This morning, I will cover just 2 of the 6 measures that we've worked on. The first bill is SB 937 by Senator Wiener, which would have prohibited local agency from requiring payment of fees or charges until the date of final inspection or the date of certificate of occupancy is issued. The local agencies would be prohibited from charging interest or other fees on any of the amounts deferred. The mandated shift in timing, by default, potentially turns local governments into loaning institutions. This measure made it out of the Assembly Committee on Housing and Community Development yesterday on an 8-0 vote and will next be heard in the Appropriations Committee. The next measure is SB 1210 by Senator Skinner. This bill would have prohibited a connection capacity or other point of connection charge from a public utility for gas, electric, sewer, water service from exceeding 1% of the reported building permit value of a new home. Additionally, the bill would have required a public utility to accept payment for these charges over a period of at least 10 years, commencing on the date the home is first occupied. Finally, this bill would have required a public utility to prioritize and process approval, scheduling, and completion of electrical, gas, sewer, and water service connections to new housing construction above all other construction. We're happy to report that as of April 22nd, Senator Skinner accepted amendments and our statewide associations moved to a neutral position. This measure made it out of the Assembly Local Government Committee yesterday on a 6-0 vote and is also headed to the Appropriations Committee. The next bill this morning deals with lawsuits stemming from Proposition 218 challenges. AB 2257 by Assemblywoman Wilson is sponsored by the Association of California Water Agencies and would create an exhaustion of administrative procedures remedies procedures for Proposition 218 protest processes. That's a lot of P's. The exhaustion of administrative remedies would apply when a local agency follows all of the steps, some of which include a minimum 45-day posting and protest period requirement, consideration and written responses to each of the protests, and specified required actions to be taken by the governing local body. Staff is supportive of this measure for two main reasons. First, we believe it will help promote dialogue and transparency with consumers and provide us an opportunity to address issues during the protest process. And second, should we elect to follow the remedies procedures, we would receive some additional protections from those Proposition 218 contests. This measure is scheduled to be heard in the Assembly Local Government on July 3rd. The next measure is SB 1255 by Senator Durazo. This measure was a gut and amend after it passed out of its House of Origin. For a little over a decade now, advocates have sought to create a rate assistance program for water customers. Historically, those proposals had local agencies collecting the funding and then sending it to the state, and that, from staff's view, was a violation of Proposition 218. More recently, in 2022, the legislature passed SB 222, and that created a statewide program, rate assistance program, but was ultimately vetoed by the governor because there was no funding attached to that measure. This year, the sponsors have taken a new approach. The proposal has agencies collecting the funds and distributing them locally. This is in an attempt to address Proposition 218 and 26 concerns. However, the devil really is in the details on this one. The sponsors are using the community choice aggregation opt-out model, which is something that staff believes is disingenuous and will cause irreparable harm to the trust we have built with our customers. The bill would require water agencies to create a low-income rate assistance program that does the following: automatically enrolls eligible ratepayers into the program. An eligible ratepayer is a household at or below 200% of the federal poverty level. The benefit to eligible ratepayers at minimum is to be 20%. It requires water agencies to automatically place a suggested voluntary contribution on the remainder of the residential customer water bills and currently wastewater bills that is sufficient to meet that 20% benefit, minimum benefit, but it cannot exceed 5% of their water or wastewater charges on the bill. If a water agency cannot provide a benefit of at least 10% or $5 to each of the eligible ratepayers, and cover their administrative costs, the water agency would have to provide crisis assistance on an ongoing basis. Administrative costs for a local agency is currently capped at 10%, and only, the way the bill is currently crafted, only wastewater customers who are co-billed with their water service would also be required to receive the assistance and also pay the charges. Roseville has been engaged in working groups on this proposal and have been successful in obtaining many revisions that have vastly improved the bill. However, as you kind of heard from all of the elements that are included, we still have significant concerns, some of which is the potential for a violation of Proposition 218. And as currently crafted, places excessive administrative burdens and costs on ratepayers that we believe will far exceed any benefits being provided. One of the major concessions that we have been able to get included in the bill so far was the grandfathering in of a local LIRA program that is in place by 2026 and meets the minimum 20% benefit and auto-enrolls eligible customers. This measure was heard in the Environmental Safety and Toxic Materials Committee this week and made it out on a 6-1 vote, and is going to be heard again on Monday, July 1st in the Assembly Committee on Energy and Utilities. The next measure this morning is dealing with extended producer responsibility. In 2010, Roseville City Council adopted Council Resolution 10-278, which demonstrates Roseville's support and efforts to enact a comprehensive statewide extended producer responsibility law that allocates end-of-life disposal costs with the producer of the product. SB 1143 by Senator Allen would create a producer responsibility program for products containing household hazardous waste by July 1st of 2027. Products to be covered would need to be posted on the Department of Toxic Substance Control's website no later than January 1st of 2026, and one producer responsibility organization would have to be approved by January 1st of 2027. Producers of the covered products will be required to join the organization and develop a plan detailing how the industry will meet the standard. The plan's costs will be proportionately distributed to members within the organization based on sales volume and relative disposal costs, encouraging less toxic alternatives and ensuring producers pay their fair share. Roseville is supportive of SB 1143 as it shifts the onus off of consumers and municipalities and onto the producers responsible for making the materials. This measure was heard in the Environmental Safety Toxic Materials Committees this week and made it out of committee on a 5-2 vote and will now be heard in the Assembly Natural Resources Committee. The next measure, it's going to be Tracy's favorite, I would like to share is SB 903 that was co-sponsored by the California Association of Sanitation Agencies. Last year, Governor Newsom vetoed similar legislation, citing a lack of regulatory oversight to properly implement the restrictions that were contained in the bill. He called on DTSC to work with the legislature and to find alternative solutions that protect consumers effectively address public health and environmental concerns. This measure sought to address issues cited in the governor's veto message by requiring DTSC to develop regulations that would enforce the ban on PFAS. PFAS is actually a substance that can potentially affect all three of the utilities under EU's umbrella. To date, Roseville is very fortunate that we have not found PFAS in our drinking water. And as a passive receiver, Roseville is supportive of source control measures that can ultimately help protect our ratepayers. Unfortunately, this measure is dead as it was held in appropriation, so will no longer be moving this year. Next, I would like to update you on the Making Conservation a California Way of Life regulation. To recap, the second draft of the conservation regulation was released on March 12th for a 15-day comment period. The revised draft contained many improvements, such as delaying enforcement and compliance deadlines to 2027. It included a temporary 20% buffer as recommended by DWR to account for data errors, and it included residential pools as a special landscape area, so they are no longer required to use 50% less water in the future. EU staff provided comments at the Water Board workshop on March 20th, and EU signed on to a water industry coalition letter, and Roseville also submitted a letter signed by the mayor. Our goal was to keep the revisions made by the Water Board staff and obtain further modifications to the regulation. In our letter, we highlighted two main concerns: inclusion of an ongoing buffer for data inaccuracies and limitations due to using moment-in-time aerial imaging, because the buffer included in the revised regulation still is only temporary. The second issue we highlighted was how the regulation would be devastating to our existing urban tree canopy that in some cases we have been nurturing for over a century. Our tree canopies are actually vital to helping combat heat island effect. On May 20th, the State Water Board released a third revised draft of the regulation for another 15-day comment period. This draft included a new variance to address existing tree canopies. Roseville participated and submitted comments through our statewide trade association seeking to make the newly introduced tree variance more streamlined and less cost prohibitive to seek. And more recently, the State Water Board released yet another draft of the regulation on June 14th for another 15-day comment period. Comments on most of those changes are technical in nature, and comments for that version is due on July 1st. However, last Friday at 4:30 p.m., the State Board released their agenda for July 3rd, and the State Board is now slated to make a determination on July 3rd on this regulation. With that, I will end my presentation on a positive note. This year, we submitted our joint Roseville and Placer County Water Agency raw water conveyance project for a congressionally directed spending. And this project will provide a backup intake further up on the American River, thereby reducing reliance on the Folsom Reservoir during times of drought. The request was for $3 million, and I'm happy to share that Senators Padilla and Butler have included it in their requests to the Appropriations Committee. Again, this is the first step in a very long process, and we don't anticipate to know anything until at least after the elections in November on the outcome. But that concludes my presentation, and I am happy to answer any questions that you may have.
Thank you, Noel. It is good news. Vice Mayor Bernasconi, any questions?
No question, but just a thank you to you and the government relations team for watching out for, I believe, excessive and unnecessary regulations that, if not for your watchful eye, would greatly impact our ability to serve our residents and operate. So, thank you.
PFAS is dead, huh?
I knew you would like it. I couldn't do a presentation
the
without
mayor
it.
gets the memo. He'll be thrilled about that. At this time, I'll open it up for public comments. Seeing none, I will close public comment, and I'll bring it back over to Mark for any closing remarks.
Okay. Final comments. committee will be in recess July and August. That reflects the congressional and legislative calendars for summer recess. So the committee won't be meeting again until Thursday, September 26th at 9 a.m.
So our next meeting will be September 26th at 9 a.m.
Right.
Awesome. All right. Vice Mayor Bernasconi, any final comments?
Nothing else. I'll just note in my calendar for the 26th. Thank you.
All right, and we will stand adjourned until September 26th. Thank you.